Welcome to the Docketing Excellence Webinar Series.
Welcome to the Docketing Excellence Webinar Series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman-Lundberg-Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence Webinar series is free. We're coming to the end of the series that we've been doing since September. However, we're going to be scheduling additional webinars throughout the rest of the year. To get additional information or to register for these webinars, go to the Docketing Excellence Series tab of the Black Hills IP website, which is www.blackhillsip.com. Also, just a note that we launched a new website recently. So if you had been going to the webinars tab, now you should be looking for the Docketing Excellence Series tab to find the information on our webinars and our seminars, both upcoming and past ones. The webinar that we are presenting today, as I said, is the 16th one in the series. Today's topic is Best Practices for Efficient Docketing of Routine Formalities, and this will be part one of what will be a three-part series. We've allowed time for questions at the end of the webinar. The questions may be submitted using the Q&A button on the control bar on your screen. You can submit a question at any time during the program, but those questions will be held in the queue until the end of the program when we'll take them all together. Before we start, I just want to remind everybody that we are hosting 3 more docketing seminars. We did one in San Jose, California in February. We have one coming up in Minneapolis, Minnesota on June 8th, which is just a couple weeks from now. We also will be presenting in Chicago in September and in Washington, D.C. in November. If you are planning to register for the Minneapolis seminar, or if you have already registered, check out Black Hills IP on Twitter and Facebook. We have a contest running right now for the attendees of the Minneapolis seminar that's coming up with an Amazon Tap as a prize. So check out Black Hills IP on Facebook and Twitter. The presenters for today's program are myself and Christy Wheeler. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years. I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Christy, welcome back. You've been to several of these. Can you introduce yourself?
Sure. Hi, everyone. I've been in the IP practice for 29 years, with 24 of those being in foreign. And I've always been in a law firm setting. Currently, I'm a foreign filing paralegal at the Schwegman-Lundberg-Wissner firm and have been there for the past 12 years. I also co-supervise the foreign case management group at SLW and help the firm with docketing processes and issues. Previously, I was with Merchant & Gould, and before that, a boutique IP firm in Des Moines, Iowa.
Well, thank you very much, Christy. I'm sure you've seen a lot of formalities in your practice.
Yeah.
Today, we're going to be talking about why it's a challenge to docket foreign formalities, discuss various approaches to docketing foreign formalities, and then we have some general observations across all countries with respect to foreign formalities, and then we'll be discussing specific countries today. And just a comment, we had planned this program to be a single program, and when Christy and I started preparing, had aspirations of covering about 20 different countries. We realized that we couldn't go into the level of detail that we wanted to in a 30 to 45 minute program. So we're going to break this up into 3 parts, and we'll be doing 2 additional webinars on formalities on the 19th of July and the 22nd of July. Or sorry, 22nd.
August 2nd.
2nd, sorry. 19th of July and August 2nd. Thanks,
Yes.
Christy. Those, between the 3 programs today and those additional 2, we will cover some of the most common countries that most people typically file in and the individual formality requirements for those particular countries. So today, for the countries we're going to cover today and for the future programs, we'll be looking at requirements for certified copies of priority documents, powers of attorney, assignments, translations, both of the application as filed and also in some instances of the priority documents, and other documents or requirements for the specific country that we're talking about. So first, Christy, why is it such a challenge to docket foreign formality requirements?
Because we work with different agents all over. They have different ways of communicating their formality requirements, and you know, there's different deadlines in each country, and different due dates generating from different activities. So the foreign agent often sends a request for the formalities prior to filing the application. We have run into a common scenario where an agent letter acknowledges our instructions to file in a certain country, and then they set out, here's what documents we need, and the due date is 3 months from filing, the local filing date. However, they haven't filed it yet, so we don't know what that date is. So, but we know it's 3 months from whenever they file the application. And then when the same agent reports out the filing of the application, they make no mention of the due dates of the documents that is required at that 3 month, 4 month, 6 months, whatever the due date is. So, because they've already mentioned it in a previous letter, so they don't reiterate it. Then how do you docket that?
Yeah, so, and let me just jump in on that. So often the workflows in the docketing department are triggered off of a document comes in, what's needed to, in response to that document and the deadline for that document are all contained in that single document, and the docketers update the docket accordingly based on that one document. But what you're saying is one of the things that makes this difficult is sometimes the agent will tell you what's needed before you have a filing date, so you can't calculate a due date.
Correct.
And then later they'll tell you, here's the filing date, which is what you need to calculate the due date, but they don't repeat what they told you in the first letter about what formalities are due.
Right.
And so it's not all coming in together at the same time to trigger a docket to add a deadline like a more typical docketing workflow would be. Is that correct?
That's correct. Also, the requirements, of course, vary from country to country.
Mm-hmm.
Sometimes they're based on a filing date or the local filing date. Other times they wait for a notification from the patent office to come in before that triggers the due date. It might be 3 months from the date of notification or however. Also, they might mention in letters that you need a power of attorney. However, they already have a general power of attorney, and for our client, or for that particular client, we don't really need a power of attorney. And that letter might indicate that we need a power of attorney and go through the whole scenario, and then the last sentence, but we already have one for you.
And so you really don't need to docket anything because they already have it.
Right. So, I mean,
Wow.
The docketer has to read the whole document.
Mm-hmm.
Sometimes to know what to docket, but also they might not say that, and they might have a general power of attorney and they really don't need it. So
there's a lot of room for error, and it's very confusing, is what I'm hearing.
yeah.
So then how do you approach docketing foreign formalities?
Okay, in preparing for this webinar, we at Schwegman have a certain way of doing it, but then it was like, okay, what are the other ways that we could, if you didn't adopt that one? And we thought about launching a deadline for each document mentioned in the agent's pre-filing letter, with the date calculated from the date of the letter. So the agent says, on May 23rd, we need 3 months from filing a power of attorney, an assignment, and a certified copy. Docketers could put from May 23rd, 3 months from then, and put those items in there. Or they might say they need a power of attorney, and that's the only document. So then a docketer could put from May 23rd, a power of attorney is due August 23rd. Mm-hmm. So that's one way we thought of. And then you could have launch the deadline based on the local filing date, where they enter national phase, or if it's a Paris Convention 12-month date, the documents are launched automatically from that. You could have a single activity called Formalities Due, and that is docketed from the earliest possible deadline. So if in China, this is just off the top of my head, say China has a 2-month deadline to get a power of attorney due, the priority document isn't due for 4 months, and an assignment due for 6 months, and those are not true dates, so don't quote me. But if that was the scenario, you docket that 2-month date, and at least you would have a deadline on your system.
So docket a generic formalities due
Right.
on the earliest date of the various items that are actually due.
Correct.
Would be one approach, right?
Right. And then, or you could have multiple deadlines, one for each of the formalities required in a particular country. So in other words, a local filing date is entered into your system and it automatically launches power of attorney, assignment, certified copy, automatically. The other scenario, and SLW does this type of activity, is we have a template that launches an activity that is called assignment, power of attorney, priority document due. And then our docketers actually add in the comment section of our database what the actual document is that the agent is telling us that they need. They need an assignment and a power of attorney. That's it. So that gets onto our system a month from the due date, or month from the filing date of the letter, mailing date of the agent's letter. This is an unfiled national phase or an unfiled application. That date is on there. That way, our group that gets those documents for us can run a report on that code and see what's out there, and they can start working on the documents at that time.
Okay. So, and I'm sure there's other ways that some of the people on the line have to approach the problem of how do you docket formalities. The first solution that you presented, Christy, would result in a docket deadline that's not the true date.
Correct.
It's an earlier date, so that's not a bad thing. You're calculating it off the agent's pre-filing letter date because you don't know the filing date yet. But it could complicate things if the agent later does notify you after the application's filed of the true date and what is due on those dates. You could wind up with 2 different deadlines for the same thing in your docket system, which could be a problem. The second solution that you talked about is the one I mentioned before, and that's if you wait till you have the filing date to docket, you have a scenario that we see often where you find out what's due before you find out the filing date, and then you find out the filing date, but you don't have in that communication what's due, and it's kind of a puzzle piecing it all together with respect to what to docket and what deadline to docket. So Schwegman has a customized approach that they've come up with that you've described that works well for the foreign department there. And I'm sure there's other approaches. If I generalize the different approaches to handling foreign formalities, I'd say you either have a pull approach or a push approach to how you docket. The pull approach is a reactive approach. It means you wait for the associate to tell you what's needed, and then you docket it and you send it. But the problem is the one that Chris used to describe there is you don't always get in a single communication everything you need to trigger that addition of that docket deadline to your docket. The push approach, on the other hand, is a more proactive approach where you proactively docket what's required by a particular country and send it to the agent, whether the agent has notified you or not of that particular deadline, and you're proactively launching those deadlines and then pushing the documents to the agent. So every organization may approach these differently, but at a high level, that's what I see as the two approaches.
The problem with having a docket automatically generate, or doctors automatically generate from a local filing date is you've got 3 or possibly 3 dates out there, and you don't know if they're true deadlines or not. Did the agent actually ask for this? Right. Do you actually need it? At Schwegman, we send assignments. If we have assignments, we send those assignments to the associates. Are they sufficient?
So if you just automatically docket the deadline and it's not based on an agent communication, it might not be something that actually needs to be done, but you're putting the date on the docket.
Correct.
With that approach.
Correct.
Yeah, so there's advantages and disadvantages of all of them, and we just wanted to present them so you can think about them and think about what works right in your context. Before we get into talking about requirements in some individual countries, we have some general observations that apply across all foreign formality requirements. And even before I go into that, let's talk about what documents we're talking about when we discuss formalities. Generally, those are certified copies of priority documents, powers of attorney, assignments, translations of either the application as filed, or in some instances, there's requirements for translations of the certified copy of the priority document, and then other miscellaneous documents or requirements in some particular countries. Now, when I listed off that list of things that we consider formalities, you'll note that I did not include declarations on that list. Declarations, other than inventor declarations filed in PCT applications, are not generally required for individual countries. So, Australia, for example, does not require an individual declaration for Australia. And most countries do not have an individual declaration for that country. That's a requirement that's more specific to US practice. So I didn't have declarations on there, and there's a reason for that. We'll talk about powers of attorney, and I apologize, I see a typo in my slide. It says powers or attorney. That should be powers of attorney. We'll correct that before we post that on the website. We'll talk about powers of attorney on all the countries we go through, and as a general rule, unless we tell you otherwise, the requirement for a power of attorney could be satisfied by either a specific power of attorney, meaning a power of attorney that actually references that particular matter, or a general power of attorney for that particular applicant. So on the slides that we're presenting, unless we say otherwise, either one is acceptable. And also note, powers of attorney generally have to be signed by a corporate officer or someone officially designated by them.
Yeah, I just want to mention that corporate officers can appoint others in their organization to sign on their behalf. It could be a multiple tier document, and you need to supply those documents with the power of attorney. So Mr. Joe Blow at XYZ Corporation appoints
Ann McCracken.
Yeah, Ann McCracken to sign on their behalf. So Ann can now sign the power of attorney or documents for that corporation. Anne got busy and she can appoint somebody, Christy Wheeler, to sign on her behalf. All those documents need to go with the power of attorney. But, you know, they can appoint different people to sign.
Okay.
So.
Then you want to keep talking about assignments?
Yes. On assignments on national stages or Paris Convention, unless there's something wrong with the U.S. assignment, you should be able to use your U.S. assignment. It should be assigning the priority rights to the earliest priority. You should have for each of your priority cases. Also, it should have the right to foreign priority, or, you know, to the foreign applications.
Yep.
And sometimes employment agreements may be used if you have an inventor that has not executed an assignment and you can no longer find them. That's a little risky to use the employment agreements, but they have been used. Hasn't been litigated, but they have been, you know, some agents say, well, do you have an employment agreement? So that's kind of, you know, if your agent is asking for a specific assignment, ask them, say it was only assigned by the inventors to the corporation. You can say, is an acceptance of assignment acceptable to you, where the corporation accepts the assignment, and we have had good luck with them accepting that type of a document, as opposed to having to have anything re-signed. So U.S. assignments usually are good. Your exception, of course, if you're first filed in China because of the inventors, you're going to need, you know, an assignment right there,
right,
from the inventors to that Chinese application or whatever. So
then the PCT Rule 92 bis.
Okay. Changes to the PCT application. Almost all the agents just need the PCT IB 306, which is the notification of a change. Where you filed the Rule 92 bis, that submission in itself, the 92 bis, is not sufficient to change it at the national phase level, because the WIPO can refuse to record that change. So you really need the 306. Sometimes if the 30 or the 92 bises are filed at the last minute, the day before the 30-month, and some agents will say, well, let me see it, that it's been filed, and they'll look to see if it's sufficient. And, you know, but WIPO also posts the 306 after it is made available, and makes available to people to look at it. So.
And if you don't have experience with that, we have an excerpt from a IB 306 form in the slides. This is the form that WIPO provides when they're notifying that they've recorded the change, right, that you've requested.
And these 92 bises is the form number that you submit to WIPO, and it changes like the address, the inventorship. You can add an inventor very easily to a PCT application after national phase. This is not easy, so you'll want to get it done before your 30-month. You change the address, the applicants, the citizenships, many of the things that would be on your request form or your demand form.
Mm-hmm. Okay. Then I just wanted to share with the audience some general information about priority documents in case you're not aware. Obviously, certified copies of priority documents are one of the most common formalities, requirements that come up in a Paris Convention country. You may not know that the USPTO can electronically exchange priority documents with certain patent offices, and there's no cost to the applicant to do this. This is the Electronic Priority Document Exchange Program, PDX, and it allows the USPTO to provide a certified copy of the priority application to participating countries' patent offices. Right now, the patent offices that participate in this program are the EPO, the Japanese Patent Office, the Korean Patent Office, the Chinese Patent Office, and then also WIPO. So in order to use this, you have to, as the applicant, have submitted PTO Form SB 39, which is an authorization to permit access to the application by participating offices. And I just have a slide showing the top portion of that form. The relevant portion for what we're talking about is the checkbox number 1, where you grant the USPTO authority to provide that copy of your application to one of those particular patent offices. Now, we're going to go into the specific formality requirements for Australia, New Zealand, Canada, Japan, and Korea next. Before we do, though, I have a polling question I'd like everybody to answer, and we'll discuss this when we get to Canada. And the question is, do you ever file applications in the Canadian Patent Office without using a Canadian agent? So without a foreign agent in Canada? That's what I'm curious to know. So if everybody can take a minute, answer that question. Let me get back to control of the screen. There we go. Whoops. So, Christy, can you talk about the formality requirements for Australia?
Sure. One thing I wanted to mention, WIPO also has a DAS, D-A-S, document exchange as well, and there's a few more countries that can grab priority documents.
Electronically?
Yes.
Okay, good.
So I just wanted to mention that. So, okay, Australia is pretty straightforward. They normally do not need a certified copy of the priority document unless it's required for the examiner. And then if the examiner asks for it, all they need is a PDF copy of it. But you're going to have to get one to make a PDF copy of it, but you don't have to send it by courier. And it's usually only when the priority date is in dispute. And typically this happens when the applicant's own art is cited. The only time a document needs to be translated is if it is in a foreign language and not in English. So there is no need for a power of attorney, and there is no requirement to file an assignment between the inventors and the applicants. But the agents that we've talked to would prefer to have it in the file because there is a requirement to file a notice of entitlement in Australia. So, and we'll talk about that in the next slide. Translation of the application is filed. We already talked about that, not needing a translation if it's filed in English. And then here the other documents that they need is the agent files a notice of entitlement. It's nothing that we need to supply to them, but if the agent has the assignment, they will know how to answer those questions in the notice of entitlement. There may be an intentional delay in order for the application not to grant. Australia grants quickly. So if everything is in order, the application could go ahead and grant. So if you filed the notice of entitlement, you wouldn't have an opportunity to possibly amend that application. So a lot of our agents wait to file that notice of entitlement.
So you're saying they intentionally delay
Yes.
that formality because they want to have a mechanism to hold off on the acceptance in case it would otherwise have been accepted right away and
Correct.
gone on to grant very quickly. And if everything else is in order, the examiner will issue a requirement for this notice of entitlement, and that slows the process down, is a way to slow the process down a little bit.
Right.
Interesting.
And you can answer that, you know, just say, yes, file the notice of entitlement, you know, based on the assignment we sent you.
Interesting.
No
I didn't
other
know they
changes.
could do that.
And then, Anne, you're doing New Zealand.
Yes. So New Zealand is very similar to Australia. There is no requirement for a certified copy of a priority document. If for some reason the examiner would require one, which is unusual, you don't have to have the actual copy of the document unless they specifically request the actual copy. No powers of attorney are needed in New Zealand. And likewise, there's no requirement for an assignment. But similar to Australia, the agent will have to file a notice of entitlement before the application is accepted. And the notice states that the applicant is entitled to a patent by way of assignment. So it's useful to have an assignment either on file or at least provided to your agent, because they will be filing this notice of entitlement similar to Australia. New Zealand does not require a translation if the application is filed in English. And a different document that's required in New Zealand is an authorization of, the agents may be required to file an authorization of agent. And this is kind of interesting. Christy, you were explaining to me that this authorization of agent form is kind of like a power of attorney, what we would think of as being similar to a power of attorney. But the unusual thing is the applicant does not have to sign it, right?
Right.
So the agent can send in a form authorizing themselves to be the agent.
Correct.
In New Zealand.
Correct.
Okay.
Just also, the agent would need the PCT IB 306, the notification of recording a change.
If there was a change.
If there was a change, but they can also find that on WIPO's website.
And this authorization of agent is not something that's always required. It's if there's a new applicant, and let's say there was an applicant added, you had the IB 306 form showing that it was added after publication, and then the New Zealand agent would have to draft up this authorization of agent for that new applicant. Correct?
Right.
Okay. All right, let's go to Canada next. Christy, can you talk about Canada?
Sure. The certified copy of the priority document, it's not required unless it's requested by the examiner, and I cannot ever remember an examiner asking for a priority document in Canada. So I have no personal experience with that. What the agents said, they will require a certification for the patent office in which the application was filed, indicating the actual date of filing. So that, you know, it was kind of an odd thing, but it's not required in Canada. The power of attorney is not needed, but you must have an agent in Canada, which is why we asked the poll question.
Yes, and this was interesting. 97% of the people responding to the poll said that they do not file without a Canadian agent, or said differently, when they file, they're always filing through a Canadian agent. But 3% of the people said that they do file applications without using a Canadian agent in the Canadian Patent Office.
Okay.
So what do they need to know?
Okay. For the people that file without an agent, we've been told that the application is considered incomplete if the applicant has failed to appoint a representative or an agent. If it is still incomplete after 15 months from the filing date or 3 months after national entry for PCT applications, the Patent Office will send a notice to the applicant that a patent agent must be appointed within 3 months from the date of notice. So just be aware that apparently you need to have an agent, and maybe our 3% could be Canadian entities that are
Could be.
registered in Canada. I don't know.
Could be.
So now the assignment, you don't need a Canadian assignment. However, our agents all suggest highly to record the assignment. Now, Canada seems to be a very easy country. They are very picky on assignments.
Really?
Yeah. So
I would not have expected that.
right. Problem with Canada, your recordation sheet is needed if your inventors have not had been witnessed by two, or signatures been witnessed by two witnesses or notarized. So many of our clients do not have their inventors notarize their assignments, so we have to have that recordation sheet. So if your recordation sheet is anything different than what your assignment is, then Canada will reject that. And so if you've submitted an assignment with informal names, and then your recordation sheet has formal names, they will recognize that. If you have a little misprint on anything, they'll Canada's real picky on their assignments. So just make sure that.
Well, that's a good tip, because I would not have expected that.
Yeah.
With Canada. Canada seems pretty easygoing about most requirements.
Yeah, and this is slide 2 is the
And actually,
proof
I
of
had that
assignment.
up while you were talking about assignments, so
okay.
I've already looked at that, and I think you gave a couple of good examples of how those issues can come up.
And then our final slide on Canada is whether or not the application needs to be translated, and if it's in English, it does not. And then the 306, recording the change in name or change of any kind. Again, they can get it at WIPO.
Okay. All right, next is Japan. So I mentioned the Electronic Priority Document Exchange Program and the fact that the Japanese Patent Office is a participant in that program, so that is one way to get the certified copy of your priority document to the Japanese Patent Office. In terms of docketing, the due date for your certified copy of your priority document is 16 months from the priority date. Now, Christy, you were talking about one of the reasons why everything's confusing. Sometimes it's based on a priority date, sometimes it's based on a filing date, sometimes it's based on a date of notification. And here's one of them that's based on the priority date, and this is a non-extendable date. However, if that priority document is not provided, the Japanese Patent Office will give you a notice stating that it's possible to late file the priority document within 2 months from the notification date of that particular notice. Then, with respect to powers of attorney, a power of attorney is not required in Japan unless the application is appealed, and appeals are not that common. So for your initial filing, you certainly do not need a power of attorney.
But if you do appeal, they need the original.
Oh, yes. And did we have that? Yes.
Yes.
If you do appeal, we need to have the original copy, not a scanned copy. Assignments are not required, but one thing that did come up in as we were preparing for this is a note on assignments. If you are going to record an assignment with the Japanese Patent Office, take note that if the application was assigned after the Japanese application was filed, then the assignment document needs to specifically reference the application number or the patent number for the Japanese matter. So the agents recommend that the assignment be recorded as soon as possible, because sometimes the original assignment document in that scenario, when it's executed by the parties, might not be sufficient. for the Japanese Patent Office. And if, obviously, as everyone knows, if you need to go and track down the parties to sign again for recordation purposes, the sooner you find that out, the better. But it's just remember that if your application is assigned after that Japanese application is on file, the assignment document needs to refer to the application number, the patent number for the matter in Japan. It sounded like you're going to say something. No?
I left the firm before it got resolved, but I'd worked on a Japanese assignment for 7 years, trying to convince them that when the assignment actually says that it's assigning foreign rights, future foreign applications, that is sufficient. But they say, no, it isn't.
And they would not accept that?
No.
Wow.
And of course, nobody was at the company, so I don't know what happened.
Perfect example of that then.
Mm-hmm. It was a long fight.
Translations. Translations are required when the application, well, if the application is filed in English, a translation into Japanese is required, and that is due 2 months from the local filing date. Correct. Then, again, if there's any changes for an application that was based off of PCT after the PCT publication date, you'd need to submit that IB 306 form. Christy, can you take Korea?
Sure. They do need a certified copy of the priority document. Now, generally, when we're talking about certified copy of priority documents needing a document, we're talking about Paris Convention filings, 12 months. Usually your document, priority document has been filed in the PCT, has been received in the PCT. You receive a PCT IB 304, which is receipt of the priority document, and that again can be found at WIPO's website. But so when they need a certified copy of the priority document, we're usually talking about Paris Convention. There are certain circumstances where the priority document was not provided at the PCT level, and it's up to national phases countries whether or not they accept a late filing of that priority document. But we're not really addressing those, but that could be a scenario where you can get requests for a certified document at a national phase.
Well, and that's a great point. So all of these countries that we've talked about so far, if the application was a national phase filing, the priority document would have come through with the PCT materials. Correct. You're saying. So you're only talking about a filing in these countries when you had a U.S. application or whatever original country you filed in, and 12 months later under Paris Convention, you then filed directly in that country's patent office. That's where these certified copy of priority document requirements typically are coming in, right?
Correct. Correct.
I'm glad you clarified that.
Yeah, I just thought of that.
Glad you said that.
Anyway, so in Korea, the deadline is 16 months from earliest priority date, and it's not extendable. And I guess if you're docketing automatic on priority documents, almost all the countries have come back with 16 months from priority date. There's a few that came back, 3 months from notice. But if you docketed a 16 months from earliest priority to get a certified copy ahead of time, that would be a good date on your Paris Convention. Okay. KIPO is a participant in the electronic priority document exchange service. And we also, if you didn't file the SB, what was it? Oh, yeah, 39? SB 39.
Yep. Sorry. You're not used to these U.S. form numbers.
No, I'm not. So, but if you're close to the deadline, but you expect that the original document cannot reach the agent in time, one of our agents suggested that we hurry up and file that PTO SB 39 or its equivalent in the U.S. So that the KIPO could arrange to get that document
themselves.
Yeah.
Good tip.
And no translation of the priority document is required. Did we have that in Japan?
You know, I think that's a country that didn't make this list that did have a requirement for a translation of the
Okay.
priority document, but it was one that will be in a future webinar.
Okay. All right. I couldn't remember that. Anyway, so no translations. We do have some that you do require a translation of the priority document as well as the application. So the power of attorney. For Korea, they will issue a notice saying that you need a power of attorney. For PCT national phase applications, the deadline will be 2 months from the issuance of the notice. And for Paris Convention applications, the deadline is 1 month from the issuance of the notice. However,
That's interesting. So
yeah.
It differs, the route, based on the route, huh?
Right. But the deadline is extendable without limit for 1 or more months at a time.
Without limit.
Right. And if anybody's been in IP practice for a while, there's been Korea for office action responses used to have monthly extensions unlimited.
So one could go for years,
Correct.
extending the deadline for a response.
Right. They're now limited to 4 months. But anyway, with
But not for the power of
not
attorney.
for, no, that's just forever.
Yeah.
If you need it. And then for the general power of attorney, Korea needs the hard copy of the original general power of attorney. And for specific, they said a color scanned copy of the specific power of attorney is sufficient. So make sure your signee is executing in blue ink. That's a help.
Again, and you talked about the variations from country to country, and this is one of these little things I wouldn't have expected in Korea. If you're sending in, if you have a general power of attorney, you have to give them the hard copy.
Correct.
But if you have a specific power of attorney, a color scan's fine.
Mm-hmm.
Why? I don't know. It's just one of those things you need to know.
In Korea, assignment is not required. And then, of course, I mean, when I send instructions to files in specific countries, I'm always sending them assignments. It's by email, it's simple, just attach it, they know, they have it, they don't need it. But anyway, so as far as the translation of the application is filed, this is due at time of filing. So you need to get your instructions to your agent, at least, I like to give them a month to give you, and with national phase applications, Korea is a 31-month, you can send it at the same time you're sending your 30-month applications. Give them plenty of time to translate. But that date is not extendable. And of course, the 306 is required if they have it, but they also can get it on WIPO. So
Great, thanks, Christy. So it's a good thing we didn't try to cover 20 countries today. What we have covered is the different approaches to, or some different approaches to docketing foreign formalities, and then some general observations that apply across all countries. And then we walk through the specific formality requirements for Australia, New Zealand, Canada, Japan, and Korea. Some of the other countries that we plan to cover in the next 2 webinars are Brazil, China, EPO, Eurasia, Germany, Great Britain, India, Malaysia, Mexico, Russia, Saudi Arabia, Singapore, and Taiwan. And if you do have other countries that you're interested in, if we have enough interest across a number of people, we could add a couple countries to this list too, just let us know. And I didn't talk about our process at the beginning of this program, but what we have done on all of these countries is reached out to agents that we work with, and in many cases reached out to multiple agents to confirm and get the specifics for this particular program. And
one thing I want to mention, I had forgotten, because my practice, I don't have to do sequence listings or biological deposits. But I think we're going to have to ask that question to these agents before our next.
So add to the list.
Add to the list of what we need.
The sequence listing or biological deposit requirement. Okay.
A few of the countries told us when we asked for other documents, they told us those requirements. Anyway.
Okay, good. All right, so just a quick reminder, you can submit questions for today's program through the Q&A button on the control bar on your screen. If you have general questions about Black Hills IP services or processes, please contact Jim Brophy. His contact information is on the screen. We do have some questions in the queue, so let's take a look at these, Christy. Let me get them, you can see them. Okay, so the first one, most docketing systems are automated and generate dates based on country law. Is the actual docketing system key, or is the docketer/agent communication, I think they mean key here. So true, most docketing systems generate dates based on country law, but honestly, for a lot of the foreign countries, Christy, it doesn't seem like even that there's necessarily this level of detail in the country law for formalities. And that's probably one of the reasons why at the firm you guys created your own custom code, because the formalities weren't necessarily being covered through the country law in that particular docketing system. So right. Is your advice then rely on what the agent's telling you?
I like to rely on what the agents tell us.
Okay.
For the deadline.
Okay.
You know, that one of the prior countries, they needed to translate the whole priority document. So if we went by, say, a 3-month deadline to get the priority document, and we sent them at 2.5 months, they're going to have to hurry up with that translation. So, you know, if they told us it was 2 months to make sure they got that document in time, I'd like that. That's just me.
Yeah.
I like to put what the agents ask us.
Okay. Next question, will the slides be shared? Yes, the materials from the program are made available on our website, www.blackhillsip.com. If you go to the Docketing Excellence tab, there's upcoming webinars, past webinars, seminars, and the materials from this and previous webinars are posted on the website.
Not always. I went to look, and I couldn't find them.
Oh, so, you know, that might have been, we just redid our website. I bet it was when we redid our website.
Okay. All right.
Double check.
Just wanted to tell you that.
This is just a comment, but it's a good comment. Maybe worth pointing out the importance of assigning the priority document. Many people overlook this step. Nice presentation, thanks. Thank you, Rick, for the feedback. And Christy, I'm sure you appreciate the value of assigning the priority document.
Yeah.
And have had seen many things that derailed when that wasn't assigned, right?
Right.
Anything else on that?
Especially when it's a provisional application. And what I like to see is the assignment on a provisional application, because that inventor doesn't have to ever sign anything. So if he has to sign an assignment, he can notice right away, well, and we've had, well, this guy isn't assigned ASINI, he didn't help on this application, and we can get those types of things if you present an assignment to the inventors who we think are the inventors. So I've seen that, where it's helped with inventor problems. So,
okay, good. Someone asked, isn't the SB 39 also contained in the IDS now? That's a great question, and I'd have to double check that. I think it may ADS is a U.S. document.
Yeah, but I don't know.
And we'll double check on that, and if it is, then that's great that that's there.
Seems like it would be a good question,
Yeah.
or a good thing to have.
Here's a great question, Kathleen. Is the information discussed in the webinars going to overlap with what is covered in the seminar in Minneapolis? And the answer is no. I intentionally did not borrow content from the webinars because I wanted people to have a reason to come to the seminar. So it does not overlap. It's different material that's covered in the seminar, and hopefully you can join us for the seminar in a couple weeks. How do the timelines for nationalized PCT, wait, let me read this. How the timelines for nationalized PCT application is applicable for filing priority documents. Okay, you got nationalized PCT application, Christy, and the timelines for filing priority documents. Any general comments on that?
I'm sorry, I was looking for another answer. So your priority document in the PCT is set, isn't it, at 16 months?
Yeah, you have a.
Months? I don't.
Yeah, there's a defined timeline for getting your priority document in, and then if you had that priority document in during the PCT, and you filed your national phase as a PCT national phase in the particular country, all that stuff would flow
right
into that country, right?
But if you didn't meet that deadline, and there are some reasons not to be able to meet that deadline,
right.
It is up to the national countries.
So it would be determined by individual national country law.
Right, and that is when you get the notice to supply us a PCT or a national phase certified copy.